Okay. Kabb, you want to teach us?
Yeah, 1 second. Just had to send a message. Yeah. Sorry about this, guys. Just rushing and nothing ever works out as you want it. Anyway, okay. Let's continue. So this is for the reverse shleima for all the cholim of Klal Yisrael. Okay. Okay, let's do some. Okay. Roasting meat in a direct exposure to a fire. Whereas meat cooking in a pot, even without any liquids, may be put up raw before Shabbos. Roasting raw meat in direct exposure to a fire is subject to the following guidelines. Shulchan Aruch states, food may never be left in direct contact with the coals, unless it can reach ma'achal ben drusai on both sides before Shabbos. Now, I think that means the majority must be cooked, or vice versa, provided that neither has cooled down completely. Okay, then mixing. Okay, here we go. Okay, mixing different hot foods. Let's just do this paragraph when we finish. One may mix different hot foods even if they contain liquids, even by pouring one on the other directly from a kli rishon, provided that neither has cooled down completely. According to the Magen Avraham, it is preferable not to pour one directly onto the other, but to ladle it from one to the other. If either has cooled down completely, one must use a spoon for the transfer, because I think it'll probably start cooking. You're going to basically start cooking it again, and that's probably forbidden.
Okay. All right. So I was going to ask you one question. By the way, Gavin, who's in the background?
It's one of Dustin's mates. So I'm just blurring it out.
Oh no, that's fine. Just because of this.
No, he does some work here sometimes for Dust. They just use they need the infrastructure, the Wi-Fi and stuff like that. So.
Okay, do you have headsets or whatever because of the subject matter?
The subject matter is that. No, he's a Jew joke. It's fine.
Oh, okay. Okay, no, that's fine. It's just when just one or two things to note, that when the Gemara talks about slavery, just in summary for anybody that gets offended, because we get sometimes some YouTube comments, pretty nobody says anything's nice. They've only got things to say that are negative, but they turn around and have
there's somebody here. You must know that these are young oaks. They're Dustin's mates. They're on the phone all the time. They're preoccupied.
No, that's fine.
They're not even focused on.
Because all I'm saying is, when you're talking about Canaanite slavery here, you must know that it was equivalent to being stuck in Afghanistan with some ISIS terrorist that you've picked up. It's that caliber of person that you're allowed to have in terms of indentured servitude, not from debts.
No, sure.
We're not exactly talking about a high caliber quality of guy, which is everybody needs to keep that in context, just as a matter of interest. So what we discussed yesterday was three basic concepts. Concept number one is talking about that when there are false testimony, the whole reason that the Adim Zimmerman don't pay for the slave back to the master and only pay him for the value of the eye, which they sought to extract from the master because the damages was only the tooth. The answer is that at the end of the day, both parties, whether it was the first group of witnesses or the second group of witnesses, agreed to the fact that the master hit the slave, and by the hitting of two organs, the first one freed the slave, and as a free man, the slave that is now a free man sued for the other organ from the other individual that hit him. And at the end of the day, the reason why he owes the master for the higher organ is because that in fact was not damage lost. It was the order in which it happened. So that's the first point. And the second point of it is neither of the sets of witnesses disagree in terms of the assault. Their point of disagreement is what was hit first, the tooth or the eye. If the tooth was hit first and that organ damage freed the slave to, as a free man saw, legal restitution for the damage of the eye, which was a higher valued organ as opposed to being damaged and first hit with the eye, that freed the gentleman, and now he sought damages on the tooth, which was the lower amount. They weren't arguing about the assault charge. Therefore, there is no question that when they were put as Adam Zimmerman, that was the point of contention. However, there are two valid points that are brought out after that, and that was, when did the Adam Zimmerman account for the action taking place? If they account after the real incident, then they don't have to pay the value of the slave to the master. If they're saying the account of events was before the actual damage, they do. Why? Because if the incident hadn't happened yet, then that was a fabrication. And therefore they owe for this the master the value of the slave as well as the organ that was damaged. Okay? But if it happened afterwards, then that incident of assault took place and that immediately freed the slave, and therefore there was no issue as far as the crime that person had, the slave owner had for assault against the slave. That crime did take place first. The only thing of argument was which organ was damaged as a free man, and the master was entitled to pay the free man who was a former slave. Then there was a second point that came across, is that basically if the master had not yet been sued in court by the slave at the time that the first witnesses attested to the injuries, the conspiring witnesses should still have to pay the entire value of the slave to the master, for the person against whom they testified was not yet liable at the time that they testified. Rather, the Brycer must be speaking of a case where he had already been sued in court, and the court had ruled that the master must free the slave and pay damages for the second injury. So that only comes into account when you're talking about the reverse of hazamah. So if your first witnesses are called to be false, you've got a problem there because there's nobody testifying to the actual original assault. So then, in that case, the Adam Zimmerman would have to pay back the value of the slave to the master as well as the actual organ. But if the Adam Zimmerman were on the second set of witnesses, there's no problem, because the first set that were not basically found to be conspiring had testified to the assault. So what it's saying is here, isn't the case where the Adam Zimmerman were the first set of witnesses and not a second set, because the Brycer brings two cases. In that case, the slave must first sue his master in court for his freedom and have won that at least, if you want to prove that the first set are Adam Zimmerman and not have to make them pay for the slave. It's pretty straightforward. A major issue yesterday, which I never understood, is since that penalty in Exodus is known as a knas, okay, which is a penalty, by your own admission you're off the hook. So why have that whole pasuk in Shemot chapter 21, verse 26 and 27? That was my question. And why could you get off just with a knas? I'm sorry I damaged somebody beyond recognition. My bad. Can I have my slave back so I can further abuse him? That doesn't make sense. So there's obviously more to it that I'm not understanding. And I can't see it in the notes at all. It would seem to imply that it is absolutely a knas and you can get off by your own admission. However, when we looked at the Bava Kamma with carrying damage, as far as I knew, that if you never troubled the court, especially for creditors and damages, and you paid the money, that you could get off on your own volition. I don't think it exonerated you completely. Maybe the case here is the same. Okay, am I making sense to you guys? Yeah. Okay. Now, what I've done is I've taken about 3 or 4 pages of Amuds and I've put it in a couple of different concepts. Okay. Has that been a time saver for you guys?
Yeah, the main thing is to simplify it. Right?
That's
As
what I would
simple as
suggest.
possible. That's, yeah. Even for yourself. That's, because sometimes it gets a bit complicated and,
Correct. So I'm trying this method. I'm not skipping pages. I don't want to go through pages in repetition. I want to talk about the core concepts in repetition only, so that you're familiar when we're dealing with the next session.
Because no, you're 100% right. Because that's all you're going to remember is the core concepts, and if that's all you remember, you hacked it then at least.
Yeah. So I didn't prepare for this session, so I had to work off memory with the summaries of that. So I hope that helped. As far as the other issue brought about yesterday, and I'm going to deal with the new issues now, but we need it, is that there was a very clever concept that Rav Acha, the son of Rav Ika, said to Rav Ashi. So remember, from where did Rav deduce that a contradiction is at the beginning of Hazamah? If you will say from the Bryce's first case, where according to Rav, the first witnesses state the master is liable to pay for the eye, and the middle witness says he's liable only to pay for the tooth, there's no proof from that case. For in the Bryce's first cases, are the middle witnesses contradicted? And the testimony set aside? No, not at all. The testimony is not set aside. Because if they had not been rendered zomimim, the testimony actually accepted by the court would have remained in accordance with them. For we would have decided the law in accordance with their testimony and would have required the master to pay for the value of the tooth. For included in the testimony of 200 zuz is the testimony for 100 zuz. Therefore, it's really the first witnesses whose testimony was contradicted and set aside. But the testimony of the witnesses in the middle had not been contradicted and set aside whatsoever. So how can then Rava prove from this case that Hazamah takes effect, even on the witnesses whose testimony was set aside on account of being contradicted? So let me just unpack that as a quick concept summary. As we said very clearly yesterday, that it didn't make a difference if the second middle set were made to be aided in Zomimim by a third set of witnesses. Okay? That's why. Because let's look at the case. The first set of witnesses say that the master first assaulted the person's tooth and then damaged his eye, which means the tooth set the slave free. As a free man, he sued the master for the eye, and the witnesses corroborated that, and therefore he owes an eye. Now, the second set of witnesses says the order is reversed. The master first had the eye, which freed the slave, and as a free man, sued the slave master for the value of the tooth. Right? And therefore, the master is much happier with the second testimony because he has to pay less money. Okay? So what's happening then is the second set are exposed as conspiring witnesses. And what the Gemara is saying is, you don't have to learn from Rava's concept of that that Hazamah is from the beginning of the contradiction. Why? Because they're not contradicted. Let's see how the halacha goes. Is that in the absence of proof, the greater damages are never paid, ever, because you have to prove it. So as we said yesterday, in the case of I go through Arthur's wall, I had a bit too much to drink, and Arthur says I owe him for the Porsche, and I say, I can't speak. This is one of the things. If you're a defendant, you can't speak for yourself. It's not the small claims court. You need an attorney to speak for you. But in those days, you could have another group of witnesses that say, no, he hit the golf. Now, in the absence of proof, unless Arthur can show that the Porsche was damaged and the golf is in perfect tact. Now, I don't know how you would do it in those days, because in these days, you just take a lot of photographs for evidence. As Arthur said very funny yesterday, there's an asterisk and obelix where he's etching pictures on the New York Times of what happened. So, which I thought was very funny. But anyway, the bottom line of it is unless Arthur can prove that his Porsche was damaged, and the court knows I went through the garage and the cars were damaged, but both of them look a little bit damaged, but Arthur's only claiming the one was damaged and the other one was damaged by a previous incident. Then in the absence of proof, you cannot extract anything from me. You need evidence. So therefore, the only thing that's actually paid out is the lower amount, which is more lenient. It's the truth. So what it's saying is here is, look, the court agrees with the verdict that both of the sets of witnesses, the first and second set, are saying that the master damaged the slave, so the slave goes free. The only point of contention is whether the more expensive eye was damaged or the less expensive tooth was damaged. I don't know if we're about to have load shedding. No, we're not. So in the absence, now Kevin said a good point, which is a point by the Meiri, is that why don't we have a halfway mark? Why don't most opinions call a halfway mark? And Kevin's point was great. The only reason is that if Kevin hit the golf, and now we said, well, Arthur's got a Porsche in his garage, let's make him pay the difference between a Porsche and a Golf. Kevin's going to be none too happy with that because he's going to say, prove it. So you can't take the middle of the road when there's no proof for it. So therefore, since the verdict in the court case goes according to the lower amount being the tooth, when they are proven to be Adam Zomimim, the reason why you don't have to set aside that testimony is because the court went with their testimony, even though they were false witnesses, because it only paid on the secondary lower claim. And Gavin asked a good point yesterday, and he said, well, if it wasn't for the second set of lying witnesses, basically the slave would have got the value for the tooth, not the tooth, the eye, which was the greater amount. So if anything, the second set of witnesses damaged that, and they should be made to pay because they lied about it instead of the eye. Okay, which I thought was a great question. The only issue that I brought to Gavin yesterday is, I agree with you. In Shemayim, it might be that, they definitely know the truth, but it might be that the person is liable for an eye and will be held spiritually accountable. But in this world, you need evidence. And unless your evidence to extract the money is relatively strong, you've got to assume that there will always be contradicting witnesses. Because even if they weren't conspiring witnesses, in a legal case, you always have two different opinions and experts and witnesses backing up and evidence backing up the respective opinions. Otherwise, you've got no business being in court unless you've got strong evidence. It's just going to cost you a small fortune. So therefore, the stronger case wins. Is it the right case? No. It's what you can it's what you can present. It's what you can prove. It's not who's right. So that was the answer to Gavin's question yesterday. So in other words, what the Gemara is saying is this is not a case where necessarily Rava would say that that Rava would say that basically the contradiction is not the beginning of the Hazamah process, because Rava would not need to say it in this Bryce's first case. There was no contradiction. The court went with them. The false witnesses, they were the low amount, which is all that could have been proven. So that's not a contradiction to the testimony, if that was the prevailing verdict. So that's not a case where Rava could apply his case. That's what the Gemara is saying. So it's not a proof that contradiction is the beginning of Hazamah. This is not a proof for it. Do you see why? Because the court went with it. Whose testimony was set aside? It was the first set of witnesses, not the Eidim Zimmerman, because they were claiming the higher amount of damages that they witnessed of the eye. They said the master owed the slave for the eye. And their testimony was set aside, not the Eidim Zimmerman, because they couldn't prove it. So in the fact that their testimony was not invalidated, the second set, and the halacha actually went like them with the verdict, they were not invalidated as witnesses by their contradiction of cross testimony, because they never cancelled each other out. The first set of witnesses couldn't prove their case. And therefore, this is not a proof for Rava. Because Rava in this case doesn't have to say that contradiction is at the beginning of Hazamah, because it doesn't actually hold water in the first case. Am I making sense before I progress onwards and give Rava's explanation?
Yeah, I think so. Kevin, you okay there?
Well, can any of you give it back to me?
No, I can't, not today.
All right. Can any of you understand? No. Can any of you understand? Is any of you lost?
No, I'm following, but I can't give it over. Not in a day.
Fine, as long as you're not lost.
Kevin, I'm following. Kevin, are you following?
I'm not entirely with the thing today. So I'm hearing everything, but it's...
Okay.
So you're saying, okay, so one of the things is, you said a few minutes ago that if they don't, both witnesses don't cancel each other out, the ones that try, is this what you were talking? And
not in this case. They wouldn't cancel each other out in the first price.
They don't.
Why? Because we've gone with the second set because they only wanted to extract the low amount. They're not cancelling each other out. A different case would cancel each other out when, for example, they made a claim that one said the slave was assaulted and another one said the slave wasn't assaulted. Like, take the case of murder. When Rava first brought the case in Sanhedrin in 27a, when it was a case where Reuven killed Shimon, right, at Santon City, were the one group of witnesses, and the other group of witnesses said Reuven didn't kill Shimon, he only beat him senseless. In that particular case, they cancel each other out because they have contradicting testimony. Here, there's no contradicting testimony. They both agreed the master assaulted the slave. The slave does get to go free. There's no contradiction. Okay, they don't cancel each other out there. They don't cancel each other out with regards to the claim of the eye and the tooth, although they're two contradicting claims, because the court has gone with the lower claim by default, unless the higher claim can be proved. So it's not cancelled out. It's gone in favor of the verdict of the second, which happens to be Adam Zimmerman. So the fact of it that the court said that we honor that verdict, and later a third set of witnesses came and said that the second set weren't even at the incident. Well, what are you going to make the Adam Zimmerman pay for here? The value of the higher value of the eye, which they sought to. Well, you make them pay. You see, Kevin, Gavin, this is a point that you did miss yesterday. We can't make them pay for the eye because Adam Zimmerman were only extracting from the master the value of the lower amount, the tooth, which is the minimum.
No, you did say that yesterday as well.
No, but you missed one thing. You said, why don't we make him pay the value of the eye? Because the Adam Zimmerman weren't trying to extract the higher amount. They were trying to extract the lower amount, which is what the court by default would pay anyway. If the Adam Zimmerman were trying to extract the higher amount, it's something I just picked up today. So,
but I think they should still.
I get it.
They're going against the guards of the art. But I understand your point.
Because the Adam Zimmerman are given the reciprocal penalty of what they intended to do to the victim.
Yeah,
they only intended the victim to pay the lower amount. So therefore, they can't get the reciprocal penalty more than what they intended. That's what the Gemara is trying to say. That's the essence of it, Kevin. And therefore, you don't need to say hazamais at the beginning of the contradiction. There was no contradiction. They never sought to extract more from this person. What are you going to do? The reciprocal penalty for more than the lower amount. They only wanted the guy to pay the lower amount. They would probably include for the master. Yeah,
but in essence, what the intention was, not to go for the low amount. The intention was to stop the higher amount. That's the way I look at it.
Yeah, that might have been the intention, but that wasn't what they sought to extract, and that's the basis.
So they're lucky, yeah.
And the master was happy because he only had liable for the lower amount.
Let's see how Rava answers.
Not the eye.
Sorry. Yeah, let's see how Rava answers this question. Rava reinterpret. The Gemara has to reinterpret Rava's proof. Rav Ashi said to him, "Indeed, Rava does not deduce his rule that contradiction is the beginning of hazamah from the Brasa's first case." So Rav Ashi is agreeing that Rava doesn't have an issue. That's not where he's deducing his proof. Rava holds that since the first case of the Brisa deals with 3 sets of witnesses, we should presume that the latter case of the Brisa, in consistency with the first case, also deals with 3 sets of witnesses. And Rava therefore deduces that contradiction is the beginning of hazamah from the Brasa's latter case, which according to him deals with the following scenario. Okay? where two witnesses came and said, the master first knocked out his tooth and then blinded his eye. And the court issued a verdict on the basis of their testimony. In other words, they awarded the slave his freedom and damages to his eye. And then two other witnesses came and said the master first blinded his eye and then knocked out his tooth. And they contradicted and caused us to set aside the testimony of the first witnesses. Okay. So basically, when there's a contradiction of testimony, like in the Bryce's second case, the court then, Gavin, must retract its original ruling and exempt the master from paying the greater damages for the eye. That's according to Rashi. Okay? And the Bryce then states that if the first witnesses were subsequently exposed as Zomimim by the third set of witnesses, they pay the value of the eye to the master, even though their testimony had already been set aside prior to them being exposed as Zomimim. Does that make sense? So in other words, what's happening is the contradicted testimony is viewed as being partially found to prove that they were already Eidim Zomimim at that point of contradiction. And it was fully established by the time the testimony of the Hazamah witnesses came about. So since the process of Hazamah had been ongoing, Gavin, from the time of the contradiction, the original testimony never became ineffective prior to Hazamah. So they cancelled each other out in terms of, as far as the verdict was concerned, but not in terms of proving that these witnesses had a bad track record. So now Rava demonstrates his proof, right? He says, if it should enter your mind to say that contradiction is not the beginning of Hazamah with the Bryce's second case, and witnesses whose testimony was set aside as a result of contradiction are no longer subject to Hazamah, because if they cancel each other out, they're then known as invalidated witnesses, and you can't make a witness that's invalidated, like he's accused of being a robber, or there's a character issue, or they've contradicted each other where the testimony is not effectively able to stand. So they can't get the reciprocal penalty because the testimony was cancelled out. It's only when it was effective and a verdict was reached but sentence was not carried out that they were effective in their testimony, and then the reciprocal payment could be done before the verdict was done, before the what do you call it? This verdict was done, but before the application of the sentencing was carried out. So we want to know, why do the conspiring witnesses pay if they cancel each other out? So the reason is the testimony was contradicted beforehand. In other words, it's proving a track record. So learn from this. Rava says that contradiction is considered at the beginning of the Hazamah process because they were already proved to be conspiring from the get-go. So the Bryce's second case is a proof for Rava. The first case doesn't necessarily contradict Rava, nor does it prove. Does that make sense, Gavin?
Yeah, I can't give it over, but I have heard you, yeah.
All right. So since you guys have heard me, although we've got 10 minutes left, I'm happy to leave it at this.
No, let's actually, we can do it. I'm going to ride my bike. I'm riding my bike to meet this oak. So let's finish, use the full 10 minutes.
Okay.
So can we ask you some questions, or do you want to add?
Absolutely. No. I'm happy to at least use this time for you to get clarity so we can move on with the buyer's response to
I say I'm not thinking, I'm thinking of different things that I'm trying to not really fully focus. But so basically, if the testimony is contradicted, if the one set of witnesses' testimony is contradicted by the other, usually the second set prevails. If they contradict the first set, then that's believed.
No.
Not so?
Not at all. Okay, so it's a good point you're raising.
Or maybe I misunderstood, because if they, like with the Hazamah, they said no, they were in Alberton. First witnesses were not in Alberton, as they claimed, they were in Springs. The second witnesses say they were with them. So the Hazamah, that's
okay. So you asked two questions here. Let me just address your question. So it's not about what order the the witnesses testified in that makes them true or false. What makes them a conspiring witnesses is when other witnesses said that they couldn't have been there to view the event because they were with this other set of witnesses in a different location, or they were seen in a different location by these other set of witnesses. Now, that's the first point. So it doesn't matter.
Yeah, another question after this. Okay.
So it doesn't matter because there's a Bryce's first case and a second case. So in the first case, the middle witnesses were proven to be conspiring witnesses. In the Bryce's second case, the first set of witnesses were proved to be conspiring witnesses. So that proves it's not the order that the witnesses were conspiring in. It's when other witnesses proved that they weren't at that location. And only then the reciprocal penalty kicks in. Not when they contradict each other, because they could just be confused about what happened in the events. That doesn't conspiring
with the tooth and the eye, you mean?
Yes, because look at this, Kevin. If you look at the screen,
how do you know?
If you look at the screen and you say, boom, boom, what order did it happen? It was the same.
How can you tell? How do you prove it?
But that doesn't mean they were seeking to take revenge and conspiring. It's only when you say, how could you witness it in Sandton when you were with us in Eastgate? Then clearly they wanted to get somebody innocent convicted, and that's when they pay the reciprocal penalty. That's the basis of it.
That the witnesses who claim to have been in Eastgate or in Sandton, and it's proven, then they must pay the reciprocal the damages that
they seek to extract from the innocent.
Yes. Okay.
Yeah. So what we were saying with the case with the tooth is that we don't make them pay for the case of the eye, because all they were doing was lying that the master should pay the lower amount. So they were only seeking to extract a low amount. So they, on the basis of their intention, they should not be made to pay more than the intention of their false testimony. They can't be, even though secretly the intention could have been to deprive the slave of the higher amount. What they intended to prove was that the master owed the smaller amount. So since that money was extracted from the master, when they're found to be caught out lying, and the court had awarded